Hi, everybody. Thanks for taking the time this morning to be with us for this legal webinar. My name is Ken Sloan. I am the Director of Stewardship and Connectional Ministries at the Discipleship Ministries office here. And because of my role with the DCMs, I'm happy to help bring you these series of pre-webinars leading up to our training that's going to be at Lake Junaluska in August. I'm happy to introduce the folks who are going to be presenting to you today. Steve Lambert is our General Counsel at the General Counsel on Finance and Administration. He has been in that role since 2014. He has served for 4 decades in a private practice law firm in Washington, D.C. He has been a senior partner for Foley & Lardner, which is a national and global firm with almost 1,100 attorneys. He's served that firm in various capacities, including chair of their finance committee and vice chair of their pro bono work that they do for legal services, but has been involved with the United Methodist Church over the years, with the Virginia Annual Conference, and has been president of the Virginia Conference Pensions Board. So he knows the church in and out. He's been the chair of one of our United Methodist related schools, Ferrum College, and has served on the board of Wesley Seminary. And so we're always happy to have Steve here and to come and unpack some stuff for us. And with Steve today is Bryan Mills, who is served in the Legal Services Department of the GCFA since 2009. And he responds to a lot of legal issues. Some of you may have contact with him already as the Associate General Counsel. Prior to joining GCFA, Bryan was in private practice right here in Brentwood, Tennessee. He has a degree from Clemson, and his law degree is from Columbia Law School. He lives in Spring Hill, Tennessee right now. So Bryan and Steve, we're so happy that you're here and be able to do this with us. And so I'm going to turn things over to you. And Bryan, you can take control of the slides.
Thank you, Ken. This is Steve Lambert. We're happy to be here today, and I'm going to be happy to also be with you all in Lake Junaluska in August. I thought at the beginning of our time together, I wanted to share just a bit about who we are, so that you know where we come from in terms of what our normal work is and our ambit of our legal activity. We are actually a department of GCFA, but a department that reports directly to the GCFA board, specifically a committee of that board on legal responsibilities and corporate governance, giving us some independence and ability to serve the church in a good way, we hope. We have 3 roles. We serve as general legal counsel to one of the general agencies of the church, GCFA. We fulfill GCFA's denominational legal responsibilities, or help it to do that. And we provide legal resources in various ways to various groups throughout the denomination, and I'd like to unpack just briefly each of those roles. As General Legal Counsel for GCFA, we are required daily to give legal advice to the General Secretary and staff of that agency and deal with a host of employee matters, including benefits not only for GCFA but for other agencies as well. We're asked to deal with corporate governance issues at GCFA and deal with legal relationships with various of GCFA's subsidiaries, the United Methodist Church Foundation for one, the United Methodist Insurance Company for another. We review a number of contracts each year, between 250 and 300. We use outside counsel at times, and we oversee their work. As part of our roles, we help with the acceptance of gifts to the denomination and Board of Trustees matters, and increasingly our time is spent answering questions dealing with the denomination's Book of Discipline. GCFA has some denominational legal responsibilities boiled down in paragraph 807.9 of the Book of Discipline. It says we are to take all necessary legal steps to safeguard and protect the interests of the denomination. a simple statement that has some complexities. You know, there's a very special nature of the United Methodist Church. We're connectional in our polity, and we need to protect that. We need to protect the special nature of the United Methodist Church, not only in the United States, but throughout the world. There are, at times, church-state constitutional law issues here in the United States, and we get involved in amicus briefs and other activities relating to those issues, as you can imagine. We are asked to protect the way we do things as United Methodists around the world. We are to protect the property interests, including the trust clause of the United Methodist Connection, and also to protect the tax-exempt status of the denomination. In a bit, we'll talk about the denomination's intellectual property and activities that we do to protect it. And finally, we protect the reputational interest of the denomination as required, especially if there is litigation involving members, laity, or clergy. We're called upon to provide resources to a number of groups within the denomination, including chancellors and bishops, district superintendents, local church and annual conference leadership, folks in other general agencies, and business administrators from the local churches. We provide written materials on the GCFA website, white papers on various things. We have a legal manual that a number of people do use a lot, I think, because we get questions about it, and other things as well. In all of the resources and the trainings that we provide, we try to remember that it is the ministry that's important, not the legal issues. And we try to emphasize the fact that we need to keep our eye on the important stuff, which is to make disciples for Jesus Christ, to transform the world. I'd like to turn now to the planned agenda. Today's topics will deal with clergy taxation issues, trademark and copyright matters, and local church incorporation. Throughout it, we'll take questions as you have them, and at the end, we'll open it up for an additional question and answer time. At Lake Junaluska, currently have planned to go through tax issues affecting churches, issues and considerations dealing with human resources and employment matters, issues that arise from mandatory reporting and registered sex offenders worshiping in the church, a number of different property issues, and probably the most important topic, anything else that you want and tell me about, especially if you tell me before I get to Lake Junaluska. My email address is slambert@gcfa.org, and if you will just reach out and let me know what specific matters are on your mind, I will make sure that we have time to deal with them when we meet in Lake Junaluska.
We're going to start with clergy tax issues, and good morning, everyone. As an initial matter, you might be wondering, why is this something we felt like we should cover? None of you, as new district superintendents, are new clergy. So while you may be familiar with these rules and have been doing them following them in relation to your tax returns for a number of years, I guarantee you that when you get to your district, there will be pastors in your district and churches in your district who are getting it wrong. And so we feel like it's a good thing to just kind of remind all of us of what the rules are, because they are not always intuitive, like many things in the tax code. And we get questions on these rules all the time. You will get questions on these rules, and I know that because I sometimes get questions from district superintendents that somebody in my district has asked me this, what do I tell them? So it's a good reminder for all of us, and now you'll have something that you can always go back to if something comes up in this area that you need to address. And of course, we're always available if things get a little out of whack. So what I'm going to focus on right now is the 4 special clergy tax issues or tax rules. You can see them all there in the list. We're going to take them one by one. But before we get there, we have to remind ourselves of who does this apply to. We have to remember that what the definitions and requirements that we're thinking about here are the IRS's definitions and requirements, the tax code's definitions and requirements. So there's a specific definition for minister. And you can see it's not just minister, it's also a minister who's receiving income with respect to services performed in the exercise of their ministry. And so that's who we're talking about, and then of course we need to figure out, well, what exactly does that mean? So we can start with who is a minister. And like many things in the tax code, there's not just a straight definition. There's a series of factors that the IRS and the regulations have developed, and you can see those factors there. At a minimum, there needs to be that first one. So if you get a question from a church or from an individual within your district about whether a particular person at a local church should be treated as a minister for tax purposes, the first thing you need to ask yourself, is this person licensed, commissioned, or ordained? If the answer to that is no, then the answer to the question you received is no. So for example, something Ken and I were discussing before we started this morning, recently got a question about a certified lay speaker. Well, the issue there is that person is by definition lay, not ordained, not commissioned, not licensed. Believe it or not, that's an issue that comes up about 3 or 4 times a year. I get a question on that from somebody either at a local church level or an annual conference level. So no, that individual will be treated just as any other lay employee in the church, even if they're doing pastoral type things. Remember, there's 2 parts to this. There's the doing pastoral things, but there's also, before you get to that, you've got to be a minister as far as the tax code is concerned. And then the other things here are fairly straightforward. Does the sacraments, conducts worship services. If at any point you get a role within the annual conference office, or maybe at a conference foundation or some other related entity or a general agency, then you might start to really care about performed services in the control, conduct, or maintenance of a religious organization, because that would still bring you under this definition. And again, there's a second part to this. It's not enough to just be a minister as far as the tax code is concerned. You can't say, well, I meet the definition of a minister and I'm working at McDonald's, and therefore what McDonald's pays me, they can give me a housing allowance. Doesn't work. There's a second part to this, which is you have to be doing services in the performance of and the exercise of your ministry. And again, these are fairly straightforward things, but you will find that it's broader than you might expect. There's some examples in the regulations that have, my favorite is an individual who was employed by a for-profit publishing house that was working on a book related to a denomination. The IRS said, that's good enough. And an important aspect there was that person had been assigned by their leadership in their denomination to work in that position at that publishing house in order to assist in creating that book. So the scope of this can be pretty broad, and it has one of my favorite words in the English language here, sacerdotal. We're lawyers, and Congress and IRS can't just say performance of religious functions. We have to say sacerdotal for whatever reason, just to make somebody ask what that word means. So now that we've got that out of the way, thought it's useful to do a couple examples just to kind of give you a framework of where some of the dividing lines might be. And normally this is something I would pose to the group that I'm speaking to, but online that doesn't really work. So I've already given you what I think are the answers here. But the first one is obvious. An ordained elder doing that's right in the pocket of what it means to be a minister and to be doing ministerial activities if you've fully ordained and you're serving a local church. We also ordain deacons, and so that presents an interesting question. The ordination part is there, but then I think it really matters what that deacon is doing. And you can see the example here as a worship director. There have been private letter rulings requested from the Internal Revenue Service regarding deacons serving at specific local churches. And in that specific instance, the IRS said, yes, this person would be a minister as far as the tax code is concerned. But those private letter rulings, which is somebody sending a situation to the IRS and asking the IRS for an answer, the IRS always says our answer is limited to the particular situation that's been presented, but it gives us an idea of how the IRS might view it in general. There were some important factors there that the IRS pointed out that mattered. The worship director was actually heavily involved in determining the worship service aspect and what types of songs should be presented and what type of message is trying to be conveyed, rather than just being a person who led the choir and all of those decisions were made by somebody else. A licensed local pastor serving at a local church, yes, of course, that meets the license, commissioned, or ordained, so you're good from that standpoint. And then, again, we've already talked about certified lay speaker, servant, or whatever other phrase might be used. The problem there is they don't meet that first requirement. And then the interesting one down there at the bottom is a retired elder serving as a paid treasurer of a local church. That one's tough. They clearly meet the minister requirement because the person is still ordained. What then becomes the question is the second part, and is that individual engaging in exercising their ministry? Being just a bookkeeper, maybe not. It's a tough call, and that's when, if you've got a local church that's wondering about this, that's probably when it's worth them to spend a little bit of money and get some specific legal advice from a professional tax advisor on how they should handle that person's payroll. With all of that out of the way, let's actually talk about the rules now that we know who they apply to. This one is very important, and it's probably the one that gets messed up most often because it's not intuitive at all. Anybody who meets the definition of a minister for tax purposes is automatically self-employed when it comes to Social Security. So what does that mean? That means as you've probably seen before, there's no FICA withheld from your paychecks. And it should never be withheld from your paychecks. It should never be withheld from the paychecks of the pastors in your district. And the local churches there should not be withholding that. That's just wrong, and it's going to create some problems, not only for the church because it's paying money that it's not obligated to pay when it's paying the employer share of FICA, but it could also create some complications for the pastor who's trying to do should be doing quarterly estimated payments for their Social Security tax liabilities. So this is an important thing, and again, it does get messed up. It still gets messed up, so just something for all of us to remember and be aware of. Rule number 2 we can deal with pretty quickly, still relates to Social Security, but in theory, anybody who meets the standard of a minister for tax purposes can make an irrevocable decision to entirely opt out of the Social Security system. The important thing here that I always focus on is, you see that second underlined phrase, this has to be a religious-based opposition to Social Security. Well, we can debate about what religious-based might be, but there's some things that clearly doesn't meet that standard. One of which is what I usually hear when somebody asks about this is they say, I think I can do better from an investment standpoint with this money myself. and so I don't want it to go into the Social Security system. Well, that's definitely not a religious-based objection. That's a financial-based objection. And anybody who wants to opt out has to fill out a bunch of paperwork and make some statements on that paperwork that are probably under penalty of perjury and et cetera. So I tell individuals, you need to make sure this is truly religious-based. And remember, this is a huge decision. It's irrevocable. There have been window legislation before when the Congress has said, okay, for the next 2 years, somebody who's opted out has the ability to opt back in. That hasn't happened in a long time. There's no guarantee it will ever happen again. So this is kind of a life-changing decision, and it should never be made without lots of thought and consideration. And again, it needs to be made for a religious reason. I have a tendency to think in the United Methodist Church, it's difficult to say there's a religious-based opposition. Though it's not there currently in the 2016 Book of Resolutions, for a number of years there's been very glowing language in the Book of Resolutions about the Social Security system. And so I think it's certainly not against any kind of core United Methodist tenet, so it would have to be some type of very personal opposition. This is who we're really talking about, Buddhist monks that have taken a vow of poverty and those types of situations. Moving on to rule number 3, this is one you've probably experienced, is that you as clergy are exempt from income tax withholding. You're not exempt from paying income tax, you're just exempt from the withholding aspect of it. What is very common practice, I believe, is for ministers to still elect to do voluntary withholding. It is a way to make sure that you're able to meet your quarterly estimated tax payment requirements. And the way to do that is, as you see that last bullet, the clergy person could still fill out the W-4 just like other employees would, do their typical exemptions for their income tax purposes. None of that helps with Social Security because it's still not subject to FICA, but what can be done is there's a blank on one of the lines where you can write in a dollar amount that will be additionally taken out. And if you have a rough estimate of what your SECA obligations are going to be for the year, you can go ahead and have that additional amount withheld as well. And then when you do your quarterly estimated payments, you can show that you've paid in a good chunk already, and maybe don't have to end up sending a check to the IRS 4 times a year. For clergy that have maybe a little bit of difficulty making sure they set enough aside when every 3 months comes up to actually send a check in, this is a good way to solve that problem. And the biggest rule probably and certainly from the extent of the number of questions that we get is the housing allowance. The rules here are pretty straightforward, but as many things, the devil's in the details. So we'll cover the basics real quick, and then maybe get into a little bit of where things can get confusing. This is Section 107 of the Internal Revenue Code, is specifically provided by statute. There's 2 subsections, each of which deal with a different aspect. One subsection excludes the fair rental value of a home that's been provided from being taxable income to the individual that's living in that home. And then the other subsection is what provides an exclusion for a cash allowance, whether that's for a parsonage or for the individual's house that they own or rent themselves. It's important to understand it's an exclusion, it's not a deduction. That means it doesn't show up on your tax return. It's not something that's taken out later, it's just not there. So if you're able to exclude $10,000, that $10,000 will never show up on your Form 1040. And it also therefore doesn't show up in the wage box on the W-2. Where it can be reported on the W-2 is box 14. That's a good way for a church to remind its pastor If there is a housing allowance, what that amount was. That's an important piece of information that individual is going to need in order to do their tax return. Finally, and this is very important as well, while it keeps that money out of taxable income, it is the opposite for taxable earning for Social Security purposes. It is included. So the fair rental value of that home is included. If there is a cash allowance, it's included when you're calculating SECA obligations. There's a couple ways it can be done. We've kind of mentioned them already. There's the in-kind provision of a parsonage. The value would include it being furnished and utilities. All of that is what can be excluded. And then sometimes there's no parsonage, or for whatever reason the pastor is not living in the parsonage, the church can provide a cash allowance. And there's lots of different terminology that floats around out here. Sometimes you'll see parsonage exclusion or housing exclusion. Conference forms have a tendency to use different terms, and I'm never quite clear to me exactly what they mean by it. I've seen forms that say housing allowance and housing exclusion on the same form. I'm not sure what's intended to be the distinction there. But you always see in GCFA literature either parsonage allowance, which is a cash allowance related to a parsonage, or a housing allowance, which is cash allowance for the home or that's either rented or owned by the minister.
Brian, I was just going to ask you, on that first part, the in-kind provision of a parsonage, just to be clear about that, if a pastor is provided for a parsonage, they don't exclude the rental value of the parsonage itself from their income, because they just have the use of that house, right? It's things in addition to that, what would it cost them to use the house? Can you explain that?
So if a local church pastor is living in that church's parsonage, from an income tax standpoint, what never shows up in that individual's taxable income is the fair rental value of that parsonage, which includes some type of estimate for furnishings and either an estimate or the actual cost of utilities. So let me give you an example. Churches can do this a number of ways, but let's take a church that provides a furnished parsonage. The pastor doesn't need to go out and buy any furniture, and the church directly pays the utilities. Whatever the total value of that is excluded from taxable income and is included in taxable earnings for Social Security. So there's no income tax paid on what that total value is, but there will be Social Security tax paid.
Right. So they don't reduce their salary by any amount of the parsonage. They just don't have to show that as a benefit.
Right. It doesn't show up. The value of that does not show up in the wage box on the W-2.
Got it. Okay. Yeah.
And again, whatever these amounts are, it just is another reminder. And just as we mentioned, while they don't show up and there's no income tax paid, there is Social Security tax obligations that need to be paid on these. We'll go through the requirements here real quick. It's important that it be done in advance. Churches should do it the year before. If charge conference is in sometime in September, October, November, thereabouts, whenever that comes, that there should be a resolution to set the pastor's housing allowance for the following year, if there is being one provided. If it's an in-kind provision of a parsonage, then you don't need to worry about it. And then, of course, it's always important to understand what can actually be excluded, and this is where a lot of the questions come in. It's the lesser of three amounts. The amount that was designated, the amount of the quote-unquote qualified expenses that are actually incurred, or the fair rental value of the parsonage, again, or the home, if we're talking about a housing allowance situation, again, including furnished plus utilities. Here's a list of qualified expenses that we know are probably okay, a few that we know are not. There's very, very little guidance here from the IRS. This is where things can get gray fairly quickly. I think this is 2018. Cable TV is a utility, I think, at this point. Internet access, obviously, where you start talking about hot tubs and things like that, I don't know. This is when you want to work with your CPA or your professional tax advisor to make sure you're not adding up anything that shouldn't be there, should there ever be an audit that occurs. Real quick, important to understand, what if it all can't be excluded? So let's say the housing allowance is $10,000, actual expenses are $9,000, and the fair rental value is $9,000. Well, what can be excluded, therefore, is $9,000, but there's a difference of $1,000 from what was not reported on the pastor's W-2. When the pastor does his or her taxes, that $1,000 needs to be added back in, so that income tax is paid on that amount. And so pastors and churches just need to work together to make sure it's worse for it to be set too low, where the designation is the lowest amount, because that's a lost opportunity for the pastor. If it's set too high, you want to try to avoid it, but that's something that can be fixed when the 1040 is done. If it's too low, then there's nothing that can be done at that point. This is a reminder that things can get a little complicated when we're talking about pensions. If you have some questions on this, you should contact our friends at Westpath. That is, we kind of focus on the income tax aspects of this. They're much more experienced on the pension aspects and can help you figure out what kind of interactions might happen. And this is where we remind you that our friends, the atheists at the Freedom from Religion Foundation, are not too fond of the housing allowance in Section 107 of the tax code, and are in their third attempt to have it declared to be unconstitutional. They've now twice had a district court judge agree that the housing allowance part, not the in-kind provision of a parsonage, but the provision of a cash allowance, is unconstitutional. The first time the Federal Circuit Court overturned that and said there's no standing, so the case went away. They've come back now a third time, had the same judge come to the same conclusion, and now it is on appeal again with the Seventh Circuit. I looked at that this morning. They are in the briefing stage, and there are many friend of the court briefs that are being filed, and I have not seen where our oral argument is yet scheduled. But this is something we constantly monitor and will be keeping you aware as significant events occur. I think whatever happens, if the circuit court rules on the merits, which hasn't happened yet, which is to say if they don't just toss it out because they say there's no standing, but they actually make a decision on the constitutionality aspect, whichever side loses, I expect will try and take this to the U.S. Supreme Court. Now I'll turn it back over to Steve.
For the next few minutes, I want to share a bit about trademark issues that we are confronted with at GCFA. The two main trademarks that are held by GCFA for the denomination, you're aware of, the image of the cross and flame, and the words United Methodist. The word Methodist isn't trademarked, but the words together, United Methodist, are. So just a couple of words about what a trademark is. It's a word or a phrase, a symbol or a design that identifies and distinguishes the source of the goods of one party from those of another. A service mark is a word or a phrase or a symbol or a design that identifies and distinguishes the source of a service rather than goods. So we have these marks registered in countries, the United States, and all over the world where we feel it's necessary to protect them. To ensure that we get to continue to have the marks, we inside the tent, inside the denomination, have to use them properly, which means that GCFA and the legal department at times were required to monitor the mark and its use. I tell people all the time that you would be surprised at how many people would like to use the cross and flame and the words United Methodist, all the way from, 78 churches in Burundi who thought it would be good to continue to use the cross and flame to raise money, to a vendor here in Nashville, Tennessee, who had a tourist trade and had a cross and flame on the side of their van in order to get United Methodist tourists to take his tour, and a lot in between. People used to have marks on some things that now become so commonly used that the word itself has taken on public meaning. For example, the word escalator used to be trademarked. It's not anymore. But we have to monitor our use of United Methodist just like we do the words cross and flame. We find that more commonly we have to ensure that the cross and flame isn't used by others, and we have to watch how it's used within the denomination so our mark is not diluted. So let's look for just a few minutes and have a little fun at looking how real-life use of the cross and flame that we find in our monitoring. The first thing we have to remember is that the image must be consistent. So these three images, I'm sure, are very pretty and they are creative, but they violate our mark because they're not consistent with it. Secondly, we have to make sure that the trademark is separated. It can't be overlaid or surrounded by text or other images. Otherwise, it becomes integrated with another trademark. So our cross and flame always has to stand alone. Here are two examples of correct usage of the cross and flame. In the one image, you'll see on the right that the cross is white. I'll bring that up to tell you that the color of the cross and flame can be altered as long as it remains solid. Here, the background is dark, so a black cross wouldn't show up. We do recommend that as people ask you questions about the cross and flame, you send them to UMCOM's United Methodist Communications Branding Toolkit found on their website. So here's a quiz. Is this an appropriate usage? And the answer is no, because there's overlapping images. Is this an appropriate usage? No, there's overlapping images, surrounding words. You can have words next to the image, but the words can't surround it. Is this an appropriate usage?
The Lego church. I want to go to Lego church.
No, this is not appropriate because the image is altered. How about this one? This is a trick question. This is so different from the cross and flame that it's been determined to be okay. It's okay because there's no room for confusion. And finally, is this one okay? Yes, because the color can be altered. So turning from trademark issues to some copyright issues, the copyright doesn't require registration. And we need to remember that the copyright rights, if you would, arise the moment an original work of authorship is fixed in a tangible medium. It's an exclusive legal right given to an originator to print, publish, perform, film, record, and to authorize others to do the same. We think of copyright as we think of literary, dramatic, musical, or artistic works. But we need to also remember that it includes software code and software itself. Again, it doesn't require registration, and it arises the moment it is made. Copyright violations are important to know and to remind your churches about. People register sometimes their copyrights for two reasons. Because there's legal advantages to registering. It includes the right to bring a lawsuit if there's an infringement. Part of the reason they register is so they don't have to prove actual damages and they just simply get statutory damages, meaning automatic ones. It can range from $750 per violation to $30,000. And if there's willful infringement, the damages can be even higher. So the way to have your churches make sure they prevent violations is to get licenses to use materials. The Christian Copyright Licensing Company is a licensing organization that gives licenses, as you are aware, for the compilation of works. The one thing that we have to watch out, though, and you should help people remind them about, is to make sure that the license is for what you need. If you stream or record your services, you need to make sure the license covers that activity. There are different licenses for different rights, and they need to be very careful and not get the wrong kind. There are other ways to get permission. You can contact the copyright holder and request permission, or you can find material in the public domain, but you can't assume the material in the public is in the public domain just because you find it on the internet. It should be marked, it could be marked, and you should be very careful. And you can use the fair use doctrine, which protects some usage. It's an exception to the copyright law if you can show that the use of material is for educational purposes. But be careful, because it doesn't give you the right to then record the educational session. You can use it, but you can't record it. Most likely you'll see churches use this exception in Sunday school situations or small group learning settings. And then finally, there is an exception for religious worship services. This exception is only for literary or musical works that are religious in nature and used in a religious service. So you can't show a popular video, and churches have gotten in trouble for using popular videos or a popular song that you can connect to a sermon. The literary or musical work must be overtly religious in nature. And again, it doesn't give you the right to record or stream the work. There are times to have your churches think about copyright before reprinting hymns, thinking about the music used during worship, Sunday school, materials used for youth activities, materials used by a choir. You need to think about it and have your churches think about it a lot. People often forget that if you're doing, for example, an exercise class, that there might be protections for use of the Zumba materials. If you have an image on a projection, you need to make sure that that image is usable. You got to remember that overall that there are folks who troll churches to find violations and then send letters asking for damages. And we've seen that it's impacted negatively the ministry of those churches when that occurs. There are guidelines that we have on our GCFA website. They're shown on this slide. I would recommend that you take the time to review those, and if you think appropriate, get the guidelines to your pastors in your district.
Thank you, Steve. I want to make sure we have enough time for questions, so I'll move through this last section fairly quickly. To borrow from Shakespeare, the question is to incorporate or not to incorporate. It's not really a question as far as we're concerned here at GCFA. As you can see, from a general standpoint, we would encourage local churches to incorporate, unless you're in West Virginia, and then my understanding is state law there prohibits churches from being incorporated. Don't ask me why, because I don't know. Reasons to incorporate, the first one there is the one that everybody thinks about, and it's probably the most significant. Should some unfortunate incident happen at a local church, if that local church is incorporated, whatever liabilities or judgments that might befall that church that will be limited to the church itself, the church's assets, and it protects the members' personal assets from having to pay for any kind of judgment or damages that might result. Sometimes in other secular situations, it makes things easier. If you do need to maybe file a lawsuit against someone as a church, if you need to enter into some contracts, it does make ownership of property a little bit smoother when it's time to buy or sell. Normally I have a slide of reasons to not incorporate. I've decided to get rid of it, but one thing I will say is it's hard to come up with a secular reason to not do it, but when it does happen, there can be some organizational confusion that results because you have a charge conference, you have a church council, you have a board of trustees, no matter what, and then there's also a board of directors of a corporation, which is probably typically the individuals who are on the board of trustees, but maybe not necessarily. And there can be some confusion about who has authority to do what. Those things can be worked out, and there's still going to be turf battles even in an unincorporated church, and so some of that can bleed over when there's a corporate form. But I just wanted to toss that out there. And then finally, something as district superintendents that we want to make sure you're aware of. This is still relatively new. It was added by the 2012 General Conference. It's a new subsection to paragraph 2529. And here the idea is we have language relating to local church deeds that say there must be a trust clause in the deed. And then we say, and then the discipline says at the end of that paragraph, 2503, well, if there isn't a deed, but any of these following things apply, which I believe are on the next slide, that makes it clear this is a United Methodist Church, the deed is going to be treated as if it has a trust clause language. So in other words, you can't avoid the application of the trust interest from the denomination just by keeping it out of the deed. Same idea here as applied to articles of incorporation or association and bylaws for local churches. Set some minimum requirements, has some language that's supposed to be there, and then says, as you can see that last bullet, that the documents will be deemed modified to meet these requirements if any of 2503.6 applies. And what's that? That's accepts United Methodist pastors, uses the name United Methodist, uses the cross and flame. So it does things that makes it clear that it's actually a United Methodist church. The one thing, the reason it's here and important for you as district superintendents, you can see the second sub-bullet. The organizing documents are supposed to be approved in writing by the pastor and you as district superintendent. So we just wanted to make sure you were aware of that. And then again, the next to last sub-bullet, any changes that happen as a district superintendent, you would also have to approve. It's kind of like the sale of property. It's a check and balance on the activities of local churches. And I think now we are at the Q&A period. Jason, are you the one who's going to let us know if we have any questions?
Absolutely, and we do have several questions already in the queue. Let me take a moment and remind folks you could submit your questions using the Q&A panel on the upper right-hand side of your screen. Just click on the question mark icon, and that's how you can submit your questions. For those of you that are on a mobile device, you'll find the Q&A panel under your menu button. Okay, so let's start with the first question. Let me just maximize that panel. Regarding 501c3 status, Bryan, Steve, how does a local church set up its 501c3 status?
There are two ways. One could go directly to the Internal Revenue Service, or you can get recognition of the 501c3 status. Church is automatically 501c3, but recognition of it through a group ruling letter. If I could, that's the general answer. It is a topic that we'll deal with in the first section of our time together in Lake Junaluska about church tax issues. But bottom line is there are two ways to do it. The easiest by far to get the recognition for a church is to go to the GCFA website and use the online application, it takes about 5 to 7 minutes to get a letter that is what they need.
Okay, wonderful. And let me just put that link in the Q&A panel to the group ruling. Okay, there we go. So you'll see that populate. There we go. So that's how you can complete the UM group ruling process, by clicking on that link there that I've put in the Q&A panel, as Steve mentioned. Okay, our next question is regarding housing allowance and pastor salary. Can a pastor claim the entire salary as a housing allowance? Would this meet the qualified expenses clause? We have a pastor that has chosen to live in an expensive home, and his salary is about the entire cost of a mortgage.
So that's not an unusual situation, especially if you have a pastor that is less than full-time and so has a lower overall salary than a full-time pastor might receive, or if you, and especially if that individual has another secular type of employment, maybe as a CPA or something like that, or has a spouse who works in the secular field and maybe has a job that makes a lot of money, and so they have, as was presented in the question, has a sizable house. So the first thing, and it's important to understand, the IRS has set no limit or cap on the percentage of a salary that can be designated as a housing allowance. To say that differently, as far as the IRS is concerned, 0% can be designated, 100% can be designated, or anything in between. What is important is that whatever that amount is still has to be compared with the fair rental value of the home, furnished plus utilities, and the actual expenses. So if an individual is, say, a part-time pastor at a church, the salary is $25,000 a year. For whatever reason, they live in a house where the approximate costs of living in that house and the fair rental value of around $25,000 also is perfectly acceptable for 100% of that salary to be designated as a housing allowance. What I tell churches is, if you have some questions about whether it truly is legitimate and is truly going to be comparable to the other two amounts that are important, have a conversation with the pastor. What you don't want to happen is to either knowingly or even ignorantly help a church employee, any church employee, but probably especially the pastor, do some funny business with their taxes. And not only do you don't want that to happen, and you don't want to facilitate that, but you also don't want the headlines on the local news report of the local pastor that there's a tax fraud, or there's tax fraud with your church's pastor. That's just not going to be good. So if you have some questions, have a conversation. Make sure, get some comfort that it's actually appropriate, but there is nothing in the IRS rules that prohibit any particular percentage from being designated.
Bryan, how about a parsonage that's in a community where the property values are very high? In terms of the pastor's Social Security, do they have to pay on the full value of a house that may be in a community where its value would be could be $1 million or something?
So it wouldn't be the $1 million. It would be whatever the fair rental value of that parsonage is, which could be, yeah, I mean, it could be the rent maybe is $4,000 a month. And so that's $48,000 of taxes that there's no income tax paid on that, but there would be Social Security tax obligations.
Okay, and our next question continues in the parsonage allowance area. Regarding the parsonage allowance, if a church pays the bills in the parsonage, how is that listed on the appropriate forms? Which boxes do we need to check off?
If the form in question is the annual conference form, I'm going to have to apologize and say I have no idea. I'll take a brief soapbox moment since somebody brought it up. I've yet to see an annual conference clergy compensation form that I believe is both clear and accurate. I've seen some that fit into one category but not one in both. And so you'll need to have a conversation with the conference to make sure you understand what it is they're looking for. What I will say is, if you have a church where all of the expenses are borne directly by the church, and there's also a parsonage allowance on top of that, you have to ask yourself, what is that parsonage allowance being used for? Because if there's no out-of-pocket expenses on behalf of the pastor living in the parsonage, that amount for it to be excluded from income has to be compared to actual expenses incurred. And if they haven't incurred any, then there needs to be a little bit of investigation there.
Okay, excellent. Thank you very much. Going to copyright and trademark, can someone use the cross and flame on a tombstone? Great question.
We have allowed that in certain circumstances and denied the right to do that in others. So the answer is it depends, and the person who wishes to do that needs to make a request of GCFA, Legal's Department, and we'll get right back to them. Okay,
and is there a particular email address, or how do they start that process, Steve?
You can just send a question to legal@gcfa.org.
Okay, I'll put that in the Q&A. Legal@gcfa.org. Okay, so you'll see that there in the Q&A panel.
Yeah, and any kind of questions can always be sent there. That is our department email inbox, and lots of us have access to it, and it'll get to the right person.
Okay, excellent. Let me just check and see what other questions we have in here. Trust clause. I did have a question regarding the trust clause. Steve or Bryan, is that a topic you'll be covering in detail at Lake J, or where can we find more information about that?
Well, we do have materials in the GCFA website, a lot of materials, question and answer materials and other things about the trust clause, and yes, it will be a topic that we'll discuss together at Lake Junaluska.
Okay, thank you very much. We had a question come in. How do you determine the fair rental value of a parsonage?
That's a good question. I think probably the most straightforward way to do it would to contact the local real estate professional who could give you an opinion on what it would cost to rent that out, or what somebody would have to pay to rent that. Of course, if you have a neighborhood where you've got a bunch of houses that are identical and maybe the one across the street is actually being rented, that might give you some indication. Or if you're in a more urban area where maybe it's a condo or an apartment or something like that, and again the units are identical, then that can give you an indication. And of course, if it's actually being rented by the church, then presumably what they're paying would be the fair rental value. Just remember, what gets added to that is the cost of furnishings and the cost of utilities. That's from the IRS standpoint, that's the fair rental value, is adding all of those together.
So, Bryan, it's not just enough to go into Zillow website and take a stab at the numbers.
I would hazard against that, because if I'm the pastor and I ever get audited, I want a piece of paper from somebody that says I've looked at comparables in the area. And I mean, again, unless you've got houses that are absolutely identical, maybe you can do some calculation on cost to rent per square foot, but each house is different, and so I would rather have somebody who knows what they're doing and does that kind of thing and determines that kind of value. Give me a piece of paper and something in writing. In my professional opinion, it's whatever amount. That's what I would want in my back pocket should the IRS ever knock on my door.
Yeah, makes total sense. Thank you for that. All right, I'm going to voice our last question here, and I'll just remind folks, you can send in your questions, even though we're running out of time to be able to answer them. I'll capture those questions and send them over to GCFA so they could follow up with you at a later point. So I'm pleased to continue to send in your questions. Our last question that I'm going to ask comes from Blake, and it's regarding incorporation. Any thoughts about a church daycare or a preschool that's being run within the church building, incorporating separately from the church?
There's nothing automatically to say that's a bad idea, and from a liability standpoint, it very well could be a great idea. The benefit there is if the preschool or the daycare or is a separate corporation, should something unfortunate happen at that preschool or daycare, if everything is done correctly, the liability would be contained within that entity. It would not bleed over to the rest of the church's assets. If the church operates it directly, and it's no different from a legal status standpoint from the Sunday school, and something happens, then the entirety of the church's assets could be subject to paying whatever might result. What I will say is things that get spun off from the church into separate legal entities and get incorporated, whether it's a preschool, a daycare, a food pantry, some type of community outreach organization, whatever it may be, if the church wants it to continue to be a church, whatever it is, daycare, preschool, etc., the church needs to be very intentional when this other entity is set up, that it provides protections for itself to maintain, for example, control over the board, so that if something starts to go sideways, the church has the ability to put individuals there who will make the correct decisions. And from the church's viewpoint, we call it kind of corporate or institutional drift can happen over the years if those types of protections aren't there, and we see it on a fairly regular basis where 15 or 20 years later, nobody on the board is United Methodist, the person who's in charge of it isn't United Methodist, maybe it's not even related to the church in any real way at any point, but it's something that the church initially funded and got going, and it can be an asset that drifts away. So that's something to be aware of. And I will also say, if it's something that wants to be included in the group ruling, the things that we would require would help protect against that type of result.